Good morning. We have a full house today. I hope everyone had a great weekend. Welcome to the First District Court of Appeals. Today is Monday, November 15. We have 5 cases on the docket this morning. 2 have submitted on the briefs. And I'm going to call out the docket. So attorneys, if you can please identify yourselves and your readiness to proceed when you hear your case. All right? So the first case that we have is Jeffrey Heiss versus Lauren Heiss, case number C230178, that we'll be arguing this morning.
Lisa Yarnell for Lauren Heiss.
Brad Berry for Jeffrey Heiss.
Thank you. And I'm sure you're both ready to proceed. All right. The next case we have is Nancy Jane Simpson versus James Edward Simpson, case number C230079. That case has submitted on the briefs. In Ray LK, case number C230384. That case has also submitted on the briefs. Then the next case we have for argument is State of Ohio versus Antoine Martin, case number C230236.
Laura Peters on behalf of the appellant, Antoine Martin, ready to proceed.
Good morning.
Paula Adams on behalf of the State of Ohio, ready to proceed.
Thank you. And the last case we have is State of Ohio versus Russell Maynard, case number C230160. That is also set for argument.
Good morning, Your Honor. Krista Gieseke on behalf of Mr. Maynard, ready to proceed.
Good morning.
Chris Conser on behalf of the State of Ohio, ready to proceed.
Good morning. All right. So, counsel, whenever you're ready, would you like to reserve time?
Yes, Your Honor. 3 minutes for rebuttal, please.
All righty. You can start whenever you're ready.
Thank you. Good morning, Your Honors. May it please the court. This case is about school placement, but the issues here are more fundamental than just a school placement case. This case asks the court to decide whether the abuse of discretion standard, whether the trial court's decision is unreasonable, means anything at all. Does it impose basic requirements on the trial court's reasoning, like following the law?
So you're challenging whether it's reasonable, arbitrary, capricious. You're not challenging whether it is wrong, contrary to law then?
Your Honor, I think those two things dovetail. So the standard by which a decision of this nature is reviewed is abuse of discretion, and that asks whether the decision is unreasonable, arbitrary, or unconscionable. And
Well, if it's contrary to law, then it's going to be an abuse of discretion.
Exactly, Your Honor. And so, and the same thing is true with respect to relying on record evidence rather than presuming facts that are not in evidence. It is our position that as a matter of law, that at least should be the case. And it's ironic how few situations that there are in the law that present that situation where a trial court is just blatantly making findings of fact that are contrary to record evidence or not following the law. But when we do see those situations, then that is an abuse of discretion and calls for reversal. So our brief made 3 key points, and I'd like to highlight each of those here today, just in a slightly different order. First, the trial court improperly placed weight on its temporary order, rather than keeping the parties on equal footing as is required by the revised code. And that, we submit, was contrary to law and therefore an abuse of discretion.
Counsel, what should the trial court have done in your perspective? I appreciate what you're saying, but then there's also this factual scenario where the child has been attending a particular school and has made certain relationships. How should the trial court weigh those facts in determining what should happen with school placement?
Your Honor, I think that is a difficult question, especially in a situation where the child would stay in the same school district. I think that here we don't really see those concerns as much as you otherwise would, because CH was going to change schools regardless of where he went to school for first grade. The Goddard School was a private kindergarten program. Although there was some testimony that he might have friends in his classroom, at Little Miami, there was no testimony that he definitely would. In fact, there could be none because there was no guarantee that he would, which in reality has borne out as things have played out this year. And the same potential for friends in his classroom was true with respect to the Oak Hill School District and Oakdale Elementary, and that is also in the record with respect to the friends that he had made in Mother's Neighborhood and who would be going to the school district there. And so in that situation where it's not going to be the same for the student, you're not going to have this kind of stability and continuity that the trial court was suggesting might happen. And so
Counselor, I mean, what you just said was that regardless, he was going to be changing schools, correct?
correct.
So this court can't just substitute its judgment for the trial courts. The trial court made a determination, and unless it was arbitrary or unreasonable, we can't just go against what the trial court's saying. So the trial court decided that this was a better placement. Can you please explain to me how it was arbitrary or unreasonable?
Right, Your
Can you
Honor.
just focus in on that when it comes to this particular issue with the other students?
Absolutely, Your Honor. So the trial court's decision, there's one paragraph in the decision that gives the reasons why she decided to make the school placement decision that she did, and those reasons were simply one, that grandparents could supposedly assist with transportation at one location rather than another. And the second reason was that the child had been going to school in the same geographic location. And
To that avail, there was an educator, Metz, who had testified that the child had become less shy in Goddard. What are we to do with that?
Your Honor, I really don't understand how that testimony was relevant to where the child would be going to school going forward, just simply because even like if that means that Goddard was a good school for him to go to, he was going to be changing schools either way. So that does not seem to weigh in favor of one place rather than another, and you'll see in the record the point was made that this was the first year that this child had actually had stability in his school situation for the course of a whole year, and you would expect that once you give a child stability and they're going to the same school every single day, that there would be that kind of response.
Was there any testimony from educator Metz that you would say was relevant to the analysis?
I did not find anything that was really relevant from her testimony as to the choice between Little Miami schools or Oak Hill schools, and in that regard, the question with respect to the choice between school districts, you really have to look at, well, what testimony was presented that differentiates between those two school districts, and that's really what the trial court didn't look at all. When you look at the reasons, the court seemed to just be saying, well, I decided that this location for school was kindergarten, and so that should be good enough now. He's doing well at a school in this general geographic location. And that really didn't keep the parties on equal footing at the final hearing like they were supposed to be.
So let's say we were to agree that none of educator Metz's testimony really weighed in at all, that it had no relevancy. Then you have both parents now testifying, right? And both are testifying as to the proximity of the school to where they live and so on, right? So it sounds like it's pretty even. Why would it be an abuse of discretion for the trial court to just call it?
Well, Your Honor, respectively, I don't think that the trial court just called an even question between two school districts by looking at, well, one factor and the other, and it's even. What the trial court did was the trial court said grandparents can help. Well, but actually, the evidence that was presented showed that paternal grandfather would be able to assist with transportation, but that Ms. Heiss testified that her mother would not be able to assist with transportation. And that really was contrary to the factual findings that the trial court made. And so what you...
Are you saying it's contrary because it was plural?
Correct, Your Honor. And there was no evidence in the record one way or the other as to whether grandparents would be able to assist at the other school location. And so there's really no suggestion that this was a factor that should weigh in favor of one school district rather than another, especially when you have this testimony that unequivocally one party is not going to have that support, which
Well,
was
that's what
trial
the
court's
entry
relying
actually
on.
says. I just looked back at it, and it says, mother testified that her parents both work and that their schedules make it hard to help with the child's transportation. So that was a trial court finding. So
That is in the findings, Your Honor. I agree. But if you look at the decision where she's what is the trial court relying on? It says something different, and she says grandparents, and then she says particularly one grandparent, but that everything about her decision is really focused on the plural, which is simply not supported by the facts, and even the trial court's own factual findings in that sense are contradicting the reasoning in the trial court's decision, and that's really what's unreasonable. And
Well, counsel, I mean, in looking at the situation, and look, this is a tough situation. The parents live far apart. The child is going to be carted back and forth no matter what. And one or both parents are going to be inconvenienced by having to drive the child back and forth to school. That's just the reality of the situation. And it looks as though the trial court, in making a determination, weighed the fact that all grandparents live in the proximity of father's school district, and that there are community ties there that don't exist in mother's school district. Why is that an abuse of discretion?
Your Honor, I'm not sure I see where in the decision that she was focused on community ties, but I think it's also it doesn't reflect the whole record and the whole situation to suggest that it's equal either way, because what we have in the record is evidence that mother works and lives very close to the Oak Hills School District, that father, one of his work locations is very close to Oakdale Elementary, and other of his work locations are closer to Oakdale Elementary than they are to his residence and to Little Miami School District. And so what you actually have, and this was argued to the trial court, but absent from the trial court's reasoning, is that during the school day, if CH is at Little Miami, there is typically only one person who is close to him, and that's paternal grandfather. Both parents are working far away. Maternal grandparents are also working far away. If CH were to go to school at Oakdale, then every single school day, his mother is close by in case of emergency, and likewise, on some days of the week, his father is also close by in case of emergency.
But counsel, isn't there evidence in the record that due to the nature of mother's job working in a healthcare profession, that she would need half an hour or so to find a substitute to take over her shift before she leaves?
That was in the record, Your Honor, and similar testimony with respect to father's ability to take off work, but the distance to Little Miami only exacerbates that problem, where if CH is close by, then that takes an hour off of the time that it would take her. And again, the trial court really just didn't seem grapple with any of these factors and focused on what had already been decided, which really seemed to place, put one foot on the scale of in favor of one party, which the law does not permit. And I think that's part of what's inherently unreasonable about this decision is the trial court really just says in her decision that she's favoring one result because of what she decided previously, even though if we look at temporary orders, they're not to be relied upon for a reason. They have to be entered quickly in a case where a decision has to be made, even though the parties haven't had the opportunity to discuss all the facts and all.
So unless there's any other questions.
I actually
from
do
the
have
panel.
another question. Counselor, ultimately, the trial court is to look at the best interest of the child, correct? Okay.
Yes.
So is the trial court permitted to consider the fact that this child has built some relationships in the Little Miami area? I mean, yes, it was because of the previous order, but is the trial court allowed to consider that and looking at what is in the best interest?
Your Honor, I think the answer to your question is yes, but here the evidence showed that the child has relationships in both school districts, and so I don't see how that is a reason to choose one school district over another on the facts that we have here. And if there are no additional questions, I will reserve the rest of my time.
Thank you.
Thank you.
Good morning.
Good morning, Your Honors. May it please the court, Brad Berry on behalf of Jeffrey Heiss. Your Honor, the trial court's decision is supported by competent, credible evidence. There was no abuse of discretion in this case. It was not unreasonable or arbitrary for the court to listen to the only witness that was brought to the court, to the trial court, besides the parties themselves testifying as to what their wishes were. And that was the direct evidence from the school teacher, Melanie Metz. Melanie Metz presented some really important testimony that was relevant. She had been the school teacher for CH for 2 years preceding the hearing on this case. She was the CH's preschool teacher. She was his immediate teacher and current teacher, and she was able to testify as to how CH had grown. She was able to testify as to how he was performing in that school as of the day of trial. She was able to testify that he had
The argument from your opponent is that the child would no longer be attending that school in which
Correct.
in which the child had thrived, and is now moving on to a new school.
The important, and I agree, Your Honor, and the important thing to remember about what Ms. Metz testified to is it was a board-certified kindergarten that worked off of the curriculum of Little Miami School District. And so not only was the curriculum similar to what he was going to what CH was going to see at Little Miami, but she also presented testimony that 8 out of the 15 classmates that he had in kindergarten at the Goddard School were also attending Little Miami. In fact, they were attending Little Miami kindergarten for the half day because it wasn't a full day, and then they were supplementing it with Goddard.
And your opponent argued, and there is testimony from mother, and I think it was something like 10 to 12 friends that the child would have going into kindergarten at her school district.
Sure, and that's fantastic. I would simply say that.
Well, I think your
Melanie Metz-
opponent's point is that it seems to be even-handed at that point.
I would say yes, except that he had participated in school with these 8 students at the kindergarten, at the Goddard School, that were going to be going to Little Miami. And we also heard really important testimony from Melanie Metz that said that he was growing with these kids, that he was a leader in that he went from not being able to write his name to being able to be a leader to these other classmates, that he had esteem, that his his whole presence had grown as a result of attending school in this school district with these students that were moving along to Little Miami.
Counsel,
And-
what about the argument that these facts really connect back to the temporary order and that the trial court should disregard them because they only result from the court's temporary order and,
Sure.
and tip in your client's favor from that posture?
I would say that it, as a practical matter, and it's a good thing, is that these party situations didn't change that much between the temporary order and the actual trial in the case. There was 9 months, but this CH was attending the same school. The parties were living at the same residences, and the court had to look at received information that was very similar to the information it had received and based its temporary decision on. That was going to happen. We had to have the court address best interest factors and its connection to school, community, friendships, how he was doing in that school were all relevant at both hearings. So, but I would say that the important thing is the school teacher didn't testify at that temporary hearing. The school teacher solidified and testified to almost every single finding that the judge issued in her lengthy decision.
And counsel, there is evidence in the record that the transportation issue on mom's end is going to be worse by virtue of the location of this new school. Sure. And that the commute is going to be substantially longer, which puts CH in the car for a long time.
Sure.
Can you address how the trial court should have considered that factor?
Sure. I agree. Mother is on a proverbial island. She lives an hour to an hour and 15 minutes away from her parents, from paternal grandfather, from father and mother's school. And that's tough. What the court heard, though, is that it's working, that he was attending Goddard School and Father's school district, and he had been absent one time in the entire school year leading up to that trial because mother kept him home sick. That's fair. So there wasn't any tardies. They were able to work the transportation. It's tough, it's difficult, and that's one of the reasons why I think the court said we have a support system built in this area that's working. We have stability and consistency in the Little Miami School District that's working for this child. Why would we interrupt that?
Well, what about the testimony from mother that the grandmother would no longer be able to help with transportation because of her job? It was only a temporary fix.
Sure. Yeah. We heard that, and then it's interesting because the trial court heard it too. And the trial court, I think, was able to gauge mother's testimony as a witness and credibility and look at the factors. I think the trial court also heard what Melanie Metz said, the teacher, that grandma is transporting.
Well, that was then.
Right.
What mother was testifying to was what was going to happen in the future.
Right. She was. I would say this, that up until the day of trial, grandmother was helping. And then after the trial, I think what you can derive from mother's testimony is that grandmother, maternal grandmother, still drove down to her residence on a daily basis to assist with their adult daughter, or not adult, but 16-year-old daughter. And so grandmother's still driving down daily. And so it was very reasonable for the court to say, okay, grandmother's still in the picture. She's still driving down to your house. Father has offered that there's lots of options for after school. There's still the Goddard School. He can take the school bus, CH can take the school bus to either grandparents' house, but if grandparents not home, he can take this bus to my house, and then grandmother can still assist with transportation at 4 p.m. when she gets off work and still drive down and help out mom, because that was the testimony of mom, is that grandmother's still driving down to my house and will still drive down to my house after this trial. So I think that was the fix, is that she still is going to help. Maybe it's not right at 3 o'clock, maybe it's at 4:15, but there's still an option there to help mom out.
Thank you.
Your Honors, just a few comments about each of the issues that were brought to the court. Issue 1, that facts were not in evidence. I believe that we have clearly established that the teacher testified to most of the facts that were relied upon by the judge in this case, that this was new evidence. I think that possibly...
One of the arguments to that avail was the entry statement with regard to grandparents.
As regard to the support of grandparents?
Yeah, she said that it wasn't reflective of the record.
Right, it was plural. And I think the judge's comment was that maternal grandparents may be able to assist.
Yeah, it says both grandparents, particularly retired paternal grandpa. So looking at the facts that are discussed in the judgment entry, it appears to be reflective of the testimony on maternal grandmother.
Right. Again, I'm not sure in terms of credibility of witnesses that the court necessarily took mother's testimony as the truth, that grandmother wasn't going to be able to assist because she had for the years preceding, and she still was.
Were you discerning that there was a credibility issue here?
Well, if grandmother wasn't able to assist, she certainly could have come in and provided testimony herself. And there was no evidence that presented to the court to say that she wouldn't be able to assist in the future, at least after.
You're not asking us to be speculative, are you? No. Okay.
No. But I would say this, that even if grandmother's not able to help, and I think that's what the court's trying to say in that first sentence is, even without grandmother's help, it's still father presented multiple options for after school. There still is a support network in Little Miami, and that father could assist in helping with transportation, getting the child down to mother. I think that's how it's working.
Well, and didn't the trial court somewhat hedge its conclusion? The language is, that the grandparents can help with transportation if need be.
Correct.
So there's some language there that suggests that this might not be a permanent solution, that it's really sort of need-based.
It's tough. Right. The distance makes it tough, whether it's at whether the school district's mom's school district or dad's school district. But yes, there was testimony that both parents are transporting. Mom's dropping off in the morning, dad is occasionally dropping off in the morning, but dad's always picking up in the evening, and mom was occasionally picking up in the evening. So yes, the expectation is the parents are still going to do it the majority of the time, but the grandparents are there, or at least one grandparent is there if need be.
And the record supports, correct me if I'm wrong, that maternal grandmother is working in Claremont County, but has some flexibility in her job schedule?
I think that's exactly the testimony, is that she was working in Claremont County. She had been working in Claremont County for years, and yet she had some type of an exemption where she was going and picking up her grandson and doing the transportation.
Wasn't there testimony, though, that was a temporary fix?
That was the testimony.
Okay.
And again, I don't believe the court is relying on either grandparent to do all the transportation all the time. I think that when grandmother was available, she would be available and help out with transportation for mother, whether it's a special exemption or her flexible schedule.
Counsel, if this decision had gone the other way and Oak Hills had been chosen as CH's school district, the party still would have needed substantial assistance for transportation. Isn't that right?
100%. yes.
It's going to take a village in this situation.
They are on competing sides of 275, Your Honor, and it's a long distance in between with lots of traffic, and so it's tough.
Thank you.
And while it might be tough, it appears, as the record reflects, that both parents are committed to make this work for CH.
They are, and CH is doing really well. The old saying, if it's not broken, don't fix it. I think a lot of that was in front of the judge. And the judge expressed herself. She was pleased that he was doing so well. She was pleased that the parties were making this work. And it wasn't a perfect situation. It's not, walk down the street to your elementary school 2 blocks away, but it was working. It's working for CH, and it was in the best interest of CH. And with that, Your Honors, thank you very much, unless there's any other questions.
Thank you. I have reserved your 3 minutes.
Thank you, Your Honor. Your Honors, the question here is more fundamental than just weighing factors. Is it an abuse of discretion for the trial court to not follow the law that requires parents to be on equal footing at the final hearing when it comes to parenting and custody issues? Is it an abuse of discretion for the trial court to use reasoning that does not match the actual facts and testimony that are in evidence?
Counsel, what would it have looked like to put them on equal footing? Would that mean that the trial court would not have considered information about CH's status at the Goddard School since the Goddard School resulted from the temporary order?
Your Honor, to the extent that when approaching the situation equally in a de novo review of in a certain sense, if there was something about the Goddard School that was actually relevant to one way or the other, then that could be considered. But I think what you see here is more than that. It's sort of the court created its own.
Let me ask you then. The testimony about the curricular ties, that the Goddard School curriculum connects to the Little Miami curriculum, is that relevant?
I don't think that connection was made in the evidence or in the trial court's reasoning with respect to that. The court was very much focused on proximity and the possibility of friends and relationships.
Are those relevant?
I don't, and again, as we stated before, I think that it's at best equal here, where there's evidence that there's relationships on both sides. What the court ignored in placing weight on its temporary order were the differences between Goddard and Little Miami that were relevant, and put all of the additional burden on mother with respect to the increased distance 15 minutes further away from her house. So instead of an hour drive, it's an hour and 15 minutes. That puts an extra 30 minutes into their morning schedule, and obviously then the same thing is happening with CH coming home at night. Again, just adding that extra time on something that maybe they made it work in a temporary scenario, and just because the parties could make it work doesn't mean that that's in the best interest of the child. Obviously, we don't have what would have happened had he been in kindergarten in Oak Hills for that year. The suggestion that, well, they made it work, they've made it work, it can still work, that's really placing that weight on what already happened, rather than saying, well, also let's consider what would have happened had he been at Oak Hills. Could they have made that work? Of course they would have made that work. They're parents who are going to make it work. Would it have been more convenient? Would CH have gotten more time with his parents if that long drive between the two locations, he's spending more of that time with a parent rather than just sitting in an extended care situation? I think you would have seen the same kind of evidence in favor of Oak Hills, and that's why it's so essential. That's why the law requires the equal footing at the final hearing, when the parties have the most opportunity to present their evidence I also wanted to talk briefly on the suggestion that grandparents should have been required to testify in order to just make the basic point that a temporary situation can't be made permanent. There's no evidence in the record that there was a credibility issue, as Judge Zayas pointed out, and the mother's testimony to that point should have, and I mean, the trial court even found that in the factual findings, as Judge Bach pointed out, that that the testimony was that she wouldn't be able to help, but that did not show up in the reasoning of the court.
So unless there's any other questions from the panel, I'll give you 30 seconds to wrap up.
Thank you, Your Honor. Those were the points that I wanted to make, and so we would just respectfully rest on the arguments that are in our brief and request that the court would find that the trial court's decision was an abuse of discretion and remand with instructions to make mother residential parent for school placement purposes.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. We wish you both a wonderful afternoon, and I wish your child a great school year as well. Thank you. Good morning. I hope everyone's doing great. Another beautiful blue sky day in Cincinnati. I'm not sure how we're getting these. Attorney Peters, would you like to reserve time?
Yes, Your Honor. I'd like to reserve 4 minutes.
4 minutes. Whenever you're ready.
May it please the court, my name is Laura Peters, and I represent the appellant Antoine Martin in this case. In our merit brief, we raised 2 issues. One, in the first assignment of error, we raised the motion to suppress, the denial of a motion to suppress the evidence, and the second one was allied offense issue. While I'd like to focus most of my time on the first assignment of error, I thought I would knock out the second assignment of error real quick in case there was any questions. In this case, as you know, Mr. Martin was charged with trafficking, marijuana, possession of marijuana, improper handling of a firearm in a motor vehicle, and carrying concealed weapon. The trial court acknowledged during sentencing that the marijuana and the trafficking probably would merge if she sentenced him to prison time if he would have violated his community control. However, the proper time to actually merge is before actually imposing the sentence, because a conviction, as this court is aware, is the sentence plus the finding of guilt.
And didn't the state essentially concede?
The state essentially conceded on that one. What the issue is in this case is the improper handling and the carrying concealed.
I mean, they conceded in a fuzzy manner, but.
Correct. But if this court takes it as a concession, I'll accept that as well. But they did not concede, the state did not concede on the carrying concealed and the improper handling. But this court in 2022 in State versus Collins had this issue before it and found that loaded on.
While I was on the panel for State v. Collins, in that case, both charges stem from the placement of the firearm under the front seat of the vehicle.
Correct.
Isn't that factually quite different than what we have here?
No, not quite different. The only difference is where the gun was located in the vehicle. The gun was in a bag behind the center console. So it was still readily accessible to Mr. Martin.
But in this case, we have testimony that begins with viewing Mr. Martin leaving the building carrying the backpack to which the firearm is contained within.
Correct.
And then entering the vehicle with the backpack and placing the backpack into the vehicle. Okay, So, I don't know if you see where I'm going with this. It seems as if the carrying concealed was completed before the placement of the firearm into the vehicle. So under the rough analysis, don't we have two separate cases here?
No, I would not agree with that, Your Honor, because the conduct of carrying the gun in the bag is continuous. So rough tells you that the essential question is what is the conduct? And the conduct is carrying the gun in the bag, and then that bag was placed in the vehicle. So that is a continuous course of
Doesn't case law tell you that when one crime is completed before the commencement of the other, you do not merge?
Some courts have held that. I don't know that the Ohio Supreme Court has actually ruled that as a definitive. But in this case, I would still say because it's a continuous, the conduct is continuous, and it ended up with the placement of the bag in the vehicle, that because you consider the conduct as a whole of what the defendant is charged with, because obviously the gun has to get into the vehicle somehow. It doesn't miraculously appear there.
If I could just add on here, let's imagine a scenario in which Mr. Martin had been arrested right before he opened the car door and got into the car. And the search produced this gun that was in the backpack. Could that have justified an arrest for carry conceal?
Yes, Your Honor.
Okay, so to continue with what she was saying, because the crime was committed before he even got in the car and had the chance to have the improper handling in a vehicle. I'm not sure how we can say that it's allied. Can you explain that to me?
Because what you have to do is you focus in on the conduct, and his conduct was not complete yet. So his conduct was carrying the gun was in the bag and continuing through with the conduct and placing it into the car. So his conduct was at that point in time is when it's completed. So that's why I would argue that the case in Collins and the one from Crosley from the Second District are similar, because the gun was found in the car and was hidden or concealed in the car.
Counsel, aren't those cases different in that the police surveillance activity in those cases did not reveal how the guns got into the cars? If I'm recalling correctly, those were traffic stops and the guns were just already found in the cars. There was an observation of how the defendants got the guns from somewhere else into the cars, but we have a different set of facts here.
I will acknowledge, yes, that both Collins and Crosley were a traffic stop. One was a canine alert after a traffic stop, which led to the investigation, or led to the search. But I still say that because if you look at Ruff, and it talks about the heart of it is the conduct, and his conduct wasn't completed until he got into the vehicle and was leaving. With that,
Do you want to turn to your first assignment?
Yes, I would like to turn to the first assignment of error. And in this case, the only witness that we had testify was Officer Pitts, who was a uniformed officer who was assigned to assist a drug and gun investigation with traffic, pulling over vehicles. And that's exactly what he did in this case, is that the detectives called him or radioed him and Officer Shielmeyer and Lane, who were in a second vehicle, to pull over this pickup truck, which ultimately what Mr. Martin was driving.
And is the knowledge imputed at that point?
So the only knowledge that we know that was imputed is that they saw him leaving this address with a bag. But what we don't know, and what the trial court relied on, in part, should making its finding of reasonable suspicion and probable cause, is this phone call that was actually made from the target of the investigation.
So was that information not relayed at that time?
That information was correct. If you look at page 49 through 50 of the transcript on cross-examination, Officer Pitts essentially indicates that he didn't know the name of Martin, wasn't sure when he had ever learned about it. He did not know the contents of the phone call, so we can't impute the knowledge to him because we don't have any information about that phone call in the record. We don't know when the phone call was made. We don't know who, more importantly, we don't know who the phone call was made to. He'll acknowledge that he doesn't actually, on page 40, at the end of page 49, carrying over to 50, that he doesn't actually know who the phone call was made to. We don't know how long the detectives were surveilling the address. We don't know if that this address was already connected to the drug and gun investigation or whether it was a totally unrelated site. There's a lot that we don't know. I can continue on. And because of what we
So
don't...
do you contest the stop itself? Because there's the stop and then there's the search.
There's a stop and then there's search. The trial court said that this was more than a traffic stop, so that it was an investigatory stop. That's what the trial court found.
But wouldn't there be enough to stop under probable cause just on the traffic violation?
If,
That's all you, I mean,
correct, there is, but based on her finding that this was really an investigatory stop, that's why I went ahead and challenged the reasonable suspicion. If this court wants to find, because the officer said that they did relay, or Officer Pitts said that the detectives did relay to him that they observed a traffic violation.
I mean, the trial court could be right for the wrong reason.
Yeah, so, but the reasonable suspicion, but again, what is the reasonable suspicion? What are the specific and articulable facts that Mr. Martin is about or is committing a crime? Because we don't know what the contraband is. We don't know if it would fit in a backpack. We don't know, that he didn't even know if Mr. Martin, when he came to the address, was he living at the address? That information was not disclosed and not testified to.
So what you're saying is that we don't know what would be a container that reasonably could contain the contraband because we don't have enough information about the contraband.
Correct, Your Honor, yes.
And so would that eliminate the automobile exception because there's no probable cause that contraband was in the car?
Correct, Your Honor, because we don't, there's a lot that we don't know. It's, you need the specific and articulable facts. What are and we don't have those. They may have existed, but Officer Pitts was not the person who could testify him to because he didn't know the contents of the phone call. He didn't know it. So all he knew was he was supposed to pull over this vehicle.
Well, let's focus on what he did say and then see in your perspective if that's enough. So as I recall, he testified that there was an odor of marijuana. He knew that it had been relayed to him that there was a traffic violation. He knew he was supposedly participating in some kind of gun investigation because I recall him saying that's why he handcuffed Mr. Martin right away for officer safety. And that's my recollection of what specifically he independently knew.
And I'm going to add that he knew that Martin was the target of the investigation.
Is that enough?
What he testified to there is sort of a conclusory, no, I mean, if that's what it actually bears out in the record, yes, it could potentially be, but that's not what we actually have here. The trial court, as far as like the marijuana finding, the smell of marijuana, and the footnote, I can't remember what page, but it was a footnote in her decision. She discounted the marijuana smell because he didn't testify he was qualified. So that wasn't a basis for searching the vehicle. Yes, he initially says that Mr. Martin was the one who received the phone call on like page 8 of the transcript. However, on cross-examination, he finally admits that the officers didn't detail the information of the phone call to him on pages 49 through 50. So you find that we're chipping away at what his testimony is. Yes, this was a drug and gun investigation, but again, you have to have specific and articulable facts. You can't just lay out a drug investigation and say guns, so we can always automatically search any vehicle that we think might be involved, because again, we don't have the specific and articulable facts, and Mr. Martin was related to this drug and gun investigation. There was testimony that he was unknown to this. There was
What I understand the record reflects is that what was communicated is that Martin was a target.
No, Your Honor. Actually, the information is that the primary target of the investigation had already been arrested, and placed a phone call.
But
to-
specifically, it was to stop Martin, and the officer verified that this was Martin before the stop was initiated.
That testimony is a little bit, no, he said he didn't know,
Okay.
he actually ends up saying he doesn't know when he ever learned the name of Martin. He was told to pull over this pickup truck, and he pulled over the pickup truck.
Okay.
So the testimony, I just looked back at this. So the testimony, he said that he believed it was a jail call, received information he was going to be moving stuff from the house to the vehicle. People were watching, and then it asks, go a little bit further. Some of the information was on the radio. There was an initial meeting. I can't recall if it was the radio or if it was the telephone. So at some point, presumably from this testimony, he either heard it on the radio or he got a telephone call that they had intercepted a jail call.
I believe from reading, he doesn't say that, because he's actually, I mean, like, initially he's asked, what do you know about Mr. Martin? He initially
he
doesn't
didn't-
even answer that question.
Right, I understand that he didn't know his name at that point. What it seems like from reading this, and the testimony is not the model of clarity. I understand that.
Great.
But from this, it appears that he was told that the primary target called someone to go to this house on Crestview to pick up contraband. And the police observed him leaving the house with a backpack. Correct? Am I correct so far?
I don't know that I necessarily agree with the first part, that he knew about the jail time, the jail phone call prior to the stop. What we do know is he was told that what he does testify clearly to is that he was assigned to this unit and he was asked to come to a certain area. And then he was asked to stop this person because a person had been seen coming out of a certain address that the officers, that the investigators were surveilling with a backpack, and got into a pickup truck and committed a traffic violation.
But he knew it was a drug investigation, correct?
Yes, he did.
Okay, thank you.
Yes.
So counsel, did he not, he learned about the jail phone call after the fact?
Based on how he answers the defense attorney's questions, that's what I would take from that, because when he was saying because he keeps saying that information wasn't relayed to me, that, he didn't know who received the phone call. So, and he just talks about it as contraband. He doesn't say, he doesn't know what was removed.
So that's your interpretation of his testimony?
Yes, and I believe that's a very fair testimony or interpretation, based on how he answers the questions on cross-examination.
So unless there's any other questions, I'll give you 30 seconds to wrap up.
Okay. So basically, we would ask this, because we would ask this court to find that there wasn't any reasonable articulable suspicion that was geared towards Mr. Martin. And because we do not know the contents of the phone call, it cannot be the basis for any probable cause search of the vehicle. So we would ask that you reverse the trial court's decision and grant them, or have the motion to suppress granted. Thank you.
Thank you. Good morning.
May I please support?
If it's okay, I'm going to jump you to the search.
Okay.
What did the officer know at the time of the search, before the search began?
Well, and I think there's been a little talk of what defense counsel's interpretation of the evidence is.
Well, that's why
and
I'm
I think that
asking you.
brings us to really what the standard of review is for this court, because as we know, the trial court was in the best position to make those factual determinations, judge the credibility, and I think here the body camera footage is significant. We have that from both of the uniformed officers, and I think what's significant in that is that we see the progression of this. You have the stops relatively fast, and then immediately you see Detectives Bodie and Wiegand are on the scene. right away. So I think to say that we're going to draw an interpretation based on just the testimony of Officer Pitts at the motion to suppress doesn't give us the full picture. I think what the trial court had in front of it and what this court must give deference to is the value that she placed on that in rendering her decision here. It's only if the trial courts, given that we have that competent and credible evidence, that it's only if the trial court's decision is clearly erroneous that we look at reversing the motion to suppress findings.
What
So
is
I don't
that
think
competent,
that
credible
is-
evidence?
Pardon me?
What is that competent, credible evidence?
Again, I think that we look at the body cam footage, that we can't say that, oh, it was yesterday that Bodie and Wiegand were looking at, or surveying the house. I mean, certainly, they're right on the scene right away, too. So I think that you look at the timing of a lot of this, and I think it's a disingenuous interpretation of that evidence that, you know, there wasn't some close connection between them intercepting the call, surveying the house,
Well,
and
wouldn't that be
calling those
stacking
officers.
inferences at that point?
I'm sorry, I didn't hear that.
Wouldn't that be stacking inferences at that point? I mean, we're not sure when the call came, correct?
Again, I don't think that when you look at the body cam footage of these, they're there almost immediately, the investigating officers. And Officer Pitts has testified that he's just there to do what he did. He's in uniform to effectuate a stop if it's necessary, if he's called upon by those plainclothes investigating officers. So I
What
think
does that tell us, counsel? I mean, I appreciate what you're saying, but help me understand exactly what it means that the two detectives were present at the scene of the stop and the search.
because I think it's important, because that's the evidence that the trial court was faced with. And that's the evidence that she was judging. And that's the evidence that this court, and her findings with regard to that evidence, is what this court has to give deference to. And I think
How
that's
does that add to probable cause? And where specifically did the trial court credit that in its probable cause calculus?
Well, her indication is that, I mean, looking at all of the evidence that was presented to her, and that's what she set forth in her written findings, finding probable cause. So
Are there other facts of probable cause besides the presence of the two detectives?
Well, and I think the fact that the radio surveillance, the radio information that's coming across, stopping a particular, the pickup truck is the description. And I believe, and I think we're taking it out of context to say that he didn't know that they had intercepted the jail call, that Officer Pitts didn't know about that. So I don't read that part of the transcript as indicating he didn't know about that. I think that all of that information was available to Officer Pitts and Officer Schildmeyer, certainly when you see their interaction from the body cam. So I don't think that there's at all a probable cause problem here, in the trial court's findings should be affirmed with that regard.
Now, with regard to the second assignment of error and the merger of the third and the fourth charges, you argued something with regard to weapons under disability. I wasn't able to follow that argument. Can you help me with that?
This is the information that was presented to the trial court. And certainly, we acknowledge the counts 1 and 2. So, but with regard to and first off, this should be evaluated under the plain error standard, because they didn't raise the issue.
Understood.
And again, we're looking at the only facts that we have come from the motion to suppress hearing, because there was a no contest plea, and so the facts that are presented at the time of the plea aren't all of the particulars. So we only get the particular facts from the motion to suppress. But I think that the point was that, and I appreciate the distinction that was made with the Collins case and the fact that, this was, the weapon was found in the backpack, and so that offense is completed at the time. I certainly agree with that. But I think that the distinction that the prosecutor pointed out at the time of the sentencing, or at the plea, I'm not sure when that came up, I think it was at the plea, was that the carrying a concealed weapon offense, the fact that he wasn't permitted to carry a weapon was a significant distinction between the improper handling. So normally, we would see this in having weapons under disability. Like, certainly you're not going to have those two aren't going to be allied, because the disability is what distinguishes it between an improper handling. But in this case, I think you can make the same analogy with, and that was the trial assistant's point, is that he did have a disability. He couldn't carry a concealed weapon, regardless if it had not been in the backpack. So I think that was the point that the trial assistant was making at the time, that was presented to the trial court, that they were making that distinction. So I don't believe that those would be allied. Unless there's any further questions, I will submit. Thank you.
Thank you. Attorney Peters, I have reserved your 4 minutes.
Oh, thank you. I'd like to address a couple points about what's in the record as far as what the state represents. The state is talking about viewing the body cam videos. However, if you look at page 4 of the transcript, the trial court only looked from up to 4 minutes and 10 seconds of Officer Pitt's Exhibit A, and on Officer Shieldmeyer's Exhibit B body cam video, they stopped at 3 minutes and 25 seconds. At both of that point in time, neither of those detectives were there. And regardless, Your Honor, Judge Kinsley, I believe you're correct. Their presence doesn't add to probable cause. We knew that they were close by because the pickup truck actually didn't travel too far from the location that they were surveilling.
Well, I understand your argument that this is what was played during the motion. Was the entire video submitted into evidence?
That was the part that they asked to be admitted, and that's what was not objected to.
So only up to that time period is what was actually
Correct, Your Honor.
evidence. Anything beyond that was not part of the record?
Yes, and I would cite this court to, it's because of this, I didn't realize this, but to State versus Crump, a decision from this court in which this court found that they would only review what was actually played for the trial court. And we know that from the beginning at the introductory part of this, that they went over what they played for the trial court, and that was the part that wasn't objected to. Secondly, while the state talks about just talking about at the plea hearing, they only talked that the only evidence in the record is what was in the motion to suppress. However, that's actually a little inaccurate, because we did have a proffer by the state in order for the no contest plea. And the paragraph above where they talk about the disability is where the prosecutor actually talks about that the marijuana and the gun were found in a bag behind the center console of the truck. So we do know where the gun was located in the truck. So there is more evidence in the record than the state was suggesting. But the main point in this case is, even whether or not Officer Pitts knew there was an intercepted phone call, he doesn't know the content of that phone call. And what this court doesn't know is when that phone call was made, how long the officers were surveilling that property. How many people were at that property? How many people did they watch come and go? Was Mr. Martin the only person who left with a backpack? The Officer Pitts could only say that.
Did the officer know that the issue was drugs?
Yes, he knew he was assigned to a gun and drugs investigation.
So does the officer need to know exactly what kind of drugs it is in order to be able to go into compartments that might contain drugs?
But No, in a different case, no, if he knew that they were looking for drugs. But again, we have that it was contraband, and the definition of contraband could have included cash that was used to, it could have been different things. We don't know what actually the target of the investigation, who made the jail call, what he was asking to be removed from the property. So we don't even know if this property was part of the drug and gun investigation until that intercepted phone call. I understand them surveilling it, but they still have to have reasonable and articulable and specific facts that go to Mr. Martin in order to search his vehicle. And we don't have that. We don't have the evidence in this case to establish that. So we would ask you to reverse the trial court and grant the motion to suppress.
Are there any other questions?
Thank
All right.
you.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. Have a wonderful afternoon. State v. Maynard. Good morning, Attorney Gieske. How are you?
Good morning, Your Honor. Good, how are you?
And, I'm sure I'm not saying your client's last name correctly, so help me
Maynard.
out.
Yes,
Maynard?
yes.
Okay, thank you. Would you like to reserve time?
I would like to reserve 3 minutes, please.
All right, whenever you're ready.
May it please the court, Mr. Conitzer? I'm going to focus on the first assignment of error today, which concerns the discovery infractions. And as you know, the Seminole Papadales case instructs that courts should examine the discovery violation and then impose the least severe sanction consistent with the purpose and the rules of discovery. So the purpose and the rules of discovery, the overarching themes in the law, are that discovery is supposed to promote due process and fair trial, and it does that by, 1, sanctioning access to evidence, and then 2, preventing gamesmanship and unfair surprise. So that's kind of our umbrella overarching rules of law we want to keep in mind. And to this end, we have the 3 Darmond or Parson factors to help assess whether the trial court abused its discretion in fashioning discovery sanctions. So that's the 3-part test, whether the failure to disclose was willful, whether prior knowledge of the non-disclosed evidence would have benefited the accused, and whether the accused suffered prejudice. So, with these concepts in mind, I'll turn to just a brief overview of the procedural background. I know you've read the briefs. And there were 5 continuances in this case. 3 of them were pretrial, really no one's fault. We don't care about those. There was delays in getting body cam. Nobody's fault. That's fine. What I am concerned with is the 4th continuance. That was the first mid-trial continuance. And what happened was trial commenced. The state called its first witness, who was Lieutenant Mitch, and then defense objected, saying this witness wasn't disclosed. So long story short, witness was not disclosed. And the trial court allowed continued the date in progress to allow the state to update their discovery. And that's what happened. The state, about a week later, filed its second discovery response. And kind of relevant to this whole thing is that its first response only disclosed 1 witness and then did not say anything about a gun test fire report. This second response disclosed all the witnesses, that's fine, and then said a gun test fire report would be, quote, provided as soon as is made available. So that was an anticipatory statement. So then trial recommences a couple of days later, no gun test fire report having been disclosed to this day. The first witness, Mitch, goes on, testifies, she's done, we don't care about that. Second witness comes on, that's Officer Contras. Officer Contras is presented with an evidence envelope that is dumped out in front of him, and the defense then objects and says, I haven't gotten a chance to see what this is. It was going to be the gun. The court permitted inspection, which is one permissible sanction, that's fine. Where things went awry is that the officer then testified, yes, I test fired this gun. And the defense objected, saying, this is the first I've heard of an actual test fire. The trial court then asked the prosecutor, where's the testifier report? This is the first time we're ever actually hearing a testifier was performed in a
Counsel,
report.
let me stop you there.
Sure.
So could the officer have testified about his activities with inspecting this gun, test firing it, in the absence of an official report? Or was this the kind of testimony that would have triggered an official report that would need to be disclosed?
I think that in line, there are different ways to prove operability, yes. But when it's viewed in the context of the way that this case unfolded, and remember that this first assignment of error is really focused on the procedural constitutional aspects, not what was actually remaining in the record. So it's our position that this kind of testimony, especially in this kind of case where pre-trial, it was the defense argued this over and over again. It was her understanding the gun didn't work, and she was waiting to see if a report would come. No report was ever forthcoming. So they proceeded with the decision to go to trial with the idea that they can't prove operability. We don't know where they're going with this. So it's really that unfair surprise, secreting of evidence is really the focus of this first assignment of error.
But what if the officer had never made a written report? Could he have just gotten on the stand and testified to his inspection of the gun anyway?
They could have possibly done that in the absence of a report. But again, the first assignment of error is not really concerned with how they could have elicited operability evidence. It has to do with the way that it unfolded and the state's evidence that was withheld, how that impacted Mr. Maynard's, his decision to go to trial, them not engaging their own expert because they truly believe the gun did not work.
So I guess I'm trying to drill into the surprise aspect
Sure.
of this. And I can certainly appreciate that on this record, it
Sure.
appears that the defense set down a course of action and was derailed mid-trial
Yes.
by evidence that they did not anticipate.
Right.
But could that have happened anyways? Could the officer have testified anyways in the absence of this report without any further disclosure by the state? What would have been wrong with that?
He feasibly could have, but remember this case, and our second assignment of error does touch upon this. Operability in this case was hotly contested, and it does come down to a highly technical. When the semi-automatic firearm is not extracting bullets from a magazine, does that render it entirely inoperable? And without, a report would have gone delved into, or at least cleared that up possibly, or put the defense on notice that they're going to make an allegation that that doesn't matter. Maybe you need to get your own expert, because that's a highly technical, mechanical argument.
So is this expert testimony?
It is definitely something that the average Joe on the street would probably not know. Does it cross the line? Then you get to, it's a really weird, you get into the standard of would the average police officer know this? Police officers and police stations have armorers whose job is to take care of the guns, and that's all they do. And that is a specific narrow knowledge. So I don't know what all the average officer knows or what is within the purview of the armorer. I don't know. I think that this highly technical inner workings of a gun might be something that not every officer even knows. So that all goes to why this...
I'm gonna piggyback on
Sure.
Judge Kinsley's question and ask it in a slightly different way.
Okay.
Okay, if we were to determine that the existence of this report, that the report should be excised from the evidence, and we were simply to look at the remainder of the evidence. So we have the evidence where Contras testified that he test-fired the gun.
Yes.
So if we had that evidence and the remainder of the evidence but no report, where would that leave us?
So a couple of answers to that. One is that I was very careful in my brief to argue that the correct remedy would be to foreclose the report and all testimony pertaining thereto. The other is that, as far as the second assignment of error goes, that really it has to do with the sufficiency, and that would be the harmless error analysis. But this first assignment of error really is, the problem is that you're going to see more cases coming down the pipe that this happens in, where there are discovery infractions and the onus is put on the defense over and over again. So it is kind of high time for this court to give some guidance to practitioners and say, here's what Rule 16 requires. Here's what you should do. Trial courts, you do have discretion, but there's that
Sure,
ladder.
the appellate court is here to give guidance. I think that's called dicta.
I would respectfully disagree. I would think that you're allowed to say that the trial court erred in fashioning. The Darmon test anticipates
Well,
the.
that's different. I mean, finding error is different
Yeah,
than giving
okay.
guidance.
Okay.
I want to get back to some of your arguments with regard to the report. As I understood the record and your argument this morning, the state had stated that they would provide it at as soon as the availability. Is that correct?
Correct.
Okay. So wasn't the soon as availability when the envelope was opened because the report was sealed within that envelope?
No, so our argument is actually the first Darmon factor is easily proven the willfulness because when the trial court actually asked, where's that report, the first prosecutor on the case said, oh, it's been in the evidence envelope sealed in the police officer, the CPD's possession the whole time. And whatever is in the possession of the police is imputed to the prosecution. So it's not a defense to say they've had it the whole time. If they have something discoverable, you have to turn it over. So that just proves the willfulness prong. No, we've
It's
had
in a
it.
sealed envelope that contains the firearm, that contains evidence.
Right.
Are you saying that that evidence envelope should have been opened by the state?
Absolutely. So for, the only thing they have to be concerned with that is chain of custody. So preserving chain of custody does not obviate their duty to follow the discovery rules. So they would presumably have whatever they always do when they take something out of evidence. There's writing, it's probably kept in a controlled environment. You can make a copy of that report. Officer that does it signs that, put it back in. That sort of thing is done all the time. Their wanting to preserve chain of custody does not obviate their discovery duties.
But to Judge Kinsley's point, the operability could have been simply established by the officer's testimony of his testing of the firearm. So where is the element of surprise? Where's the element of surprise that this is so egregious that rather than taking sort of the least onerous path of a continuance, that the trial court should have not allowed the officer to testify?
The surprise lies in the fact, again, you look at I think it was at least a half a dozen times that counsel said, we proceeded with the trial because we thought we thought the gun didn't work, no report was forthcoming. Like I said, this is a highly technical function of a firearm, so certainly if they thought a report was forthcoming and they could prove operability, that they would possibly engage their own expert, that they would counsel could have at least educated herself possibly to tailor her cross to that specific mechanical
But isn't
workings.
that what the continuance was for? I mean, in theory, doesn't a continuance allow for those activities?
It does in part, but that's where you look at the big picture. This was the second in progress continuance. This is the 11th hour. Discovery is supposed to be completed well before trial starts, at the bare minimum before. And then the trial court sort of faulting defense counsel saying you should have filed a motion to compel. Motions to compel are due 7 days prior to trial. You should have filed a motion in limine. How do you know to move to exclude something you don't know exists? And putting the onus on counsel is doing a burden shifting that this court referenced in a recent decision that's sort of improper. It is not the defense's job to marshal the state's evidence. Certainly that would be unethical to even call up and say you missed something. That's not in the client's best interest. That is not how this adversarial system should operate.
Can I go back to something that you said, and I know it's referenced in your brief as well. You suggest that Mr. Maynard decided to take this case to trial based on the idea that he had an operability defense. Mm-hmm. As compared to what? What other options would he have had, and are those documented somewhere in the record?
The only thing that I know that counsel made a fleeting reference to possibly accepting a plea or entertaining a plea. She also, I think, made a brief reference to possibly obtaining an expert. So altering, I don't know that it would have necessarily changed the operability defense to that degree, but altering the entire preparation of the defense, I guess, and how they proceeded, or possibly taking a plea. I don't know. Even if it was a plea as charged, why go through all if they have clear evidence to prove every element, why go to trial type of thing? So I don't know.
All right, that's helpful, thank you. And to what degree does it matter that this was a bench trial as opposed to a jury trial in looking at the prejudice? So would the prejudice have been more severe in a jury trial situation, or should we weigh that at all?
I think because the bench is presumed to follow the proper law, prejudice is always a bit easier to meet in jury trials. However, because this is a procedural constitutional inquiry, I don't think the fact that it's bench versus jury really weighs on the first assignment of error at all. Possibly not the second, I haven't thought that through. So it is our position that, this, and like I said, this is going to keep happening, and, Rule 16 was revamped back around 2010. And I think that was the High Supreme Court signaling, we want the rule of discovery to mean, the rules to mean something. We want these to be followed. We want, this is a search for the truth, not hiding the ball, and that's what this case is a perfect example of, is how long, like I said, tongue in cheek, how long do you hang out on that bottom rung of the ladder of sanctions before you just keep continuance after continuance, especially when trials are already in progress? That is far too late to keep shoring up discovery omissions. And I won't touch too much on it. The second assignment of error, I think there's a couple of interesting...
I'll give you 30 seconds unless there's any other
Okay.
business from them.
I'll just briefly say about the second. The two kind of interesting issues are the operability issue and then consumption versus impairment. I had quoted where the 12th District kind of went into what's required for this offense, but I think that's an interesting legal, academic issue this court could address as well. I will reserve the remainder of my time then. Okay.
Thank you.
Thank you.
Good morning.
May it please the court.
So, Attorney Gieske basically, in essence, is arguing that there was a trial by ambush.
Correct. And I do know that's what she spent most of her time up here speaking about, so I was going to kind of address some of those questions off the bat, kind of away from my outline. But specifically going to what Judge Kinsley was talking about, under Evidence Rule 602, witnesses can testify to their personal knowledge. So one of our arguments here is that even without the testifier report, an officer undergoes the training, the kind of experience that they have in that role to fire these guns that they recover and kind of determine that. So under Evidence Rule 602, even without that report, our position is that that evidence is perfectly admissible and can go towards that element operability when we're talking about these kinds of gun cases.
And the officer was disclosed as a witness.
I believe he was. I'm not sure if he was on the first or the second discovery response, but he was disclosed prior to the testimony.
But to Attorney Giske's point of argument is that by there being no disclosure that there would be something beyond the officer's testimony, that there would be a report, something more technical.
And I think that was included in
that it disallowed the defense from the opportunity of perhaps pursuing their own expert.
Correct. We do believe that was disclosed in a supplemental discovery response. That's the available upon receipt kind of thing. But it was in that sealed envelope. I would also argue that there are several other ways the defense could have known that this was going to be met at trial. Again, it was in that supplemental response.
Well, isn't it your responsibility? I mean, it's in the police officer's possession. He knows he created the report.
Correct.
Once he knows it and there's been a request made, it's on the state to turn it over, isn't it?
I agree. That is correct. The motion to compel standard does impute the police to the city, to the state. But the defense, again, this is here to be fair to both sides. The defense knows it's out there. They never filed a motion to compel.
And didn't the state know that operability was going to be an issue because the defendant himself, at the time of his arrest, said that he was outside test firing the gun because it was broken?
Correct. But I would argue the defendant knew that it was operable because there were spent shell casings, there were gunshots that were heard. I believe he admitted to firing the gun into the ground to the police officers.
And ShotSpotter is how this all began.
Correct. So the defendant, I believe, while that may have been, the state may not be able to prove it at trial without the testifier report, I think Mr. Maynard was well aware the gun was operable at the time he was using it in that backyard on Gilsey Avenue.
Is it reasonable to ask a defense attorney to make a motion to compel a report that they hope doesn't exist. Because I guess what I'm saying is that it seems like that would be working against the defendant's best interest.
Again, Criminal Rule 16 is there to promote fairness to both sides. So I think the judge in this case mentioned that when he was talking to defense counsel on the record, that you know it may be out there, you know it may exist, not asking for it, not trying to prepare your best defense is kind of playing a little bit surprised at the state when you get up there and then say, well, it was in the discovery response, I never got it. And I would specifically point this court to State v. Pittman, which I believe is from 2022. That involved defense receiving discovery the morning of trial, requesting a continuance. That continuance was denied. So they appealed it based on an abuse of discretion for denying that continuance, and this court essentially pointed out that the defense never filed a motion to compel. There was no motion in limine. They knew going into trial. At that point, in this case, in Pittman, they did not have any defense or any discovery.
What would you say is our standard of review?
For the discovery issues, it's going to be the abuse of discretion, whether the judge's decisions were unconscionable, arbitrary, unreasonable, and specifically, we obviously believe that's not the case because under Criminal Rule 16L, one of the remedies the court can grant during these proceedings, if it comes up that there are still outstanding pieces of discovery, is grant a continuance. And under State v. Lakewood, as Attorney Gieseke mentioned, the court is supposed to impose the least severe sanction that is consistent with those rules of discovery.
But in looking at that, one of the things that we would be looking at is prejudice.
Mm-hmm.
And that goes back to Attorney Gieseke's argument this morning of it truncating the opportunity for using their own expert.
And so that's actually specifically what Pittman goes to, is that third element of Darmond, and stating that because there was no attempt from the defense, I believe the quote, I didn't actually have the direct quote there, but the holding was essentially the third Darmond factor was not met because the defendant did not make any attempt to compel discovery. So I would argue that following Pittman, that third element would not be met based on that lack of conversation with the state.
Counsel, I want to make sure I understand the record here. So after that second trial continuance, when the evidence bag was open, the report was in there, in the bag, was there another supplemental discovery disclosure where a formal copy of the report was actually turned over to the defense?
I'm not positive we turned over a formal copy, but there was the continuance given for the defense to at least examine that copy that we have. I would presume that I would hope we gave over a formal copy, but I don't have that information exactly off the top of my head.
Okay, would the record reflect whatever was done in that regard?
If I had a copy of the discovery response, most likely. I don't recall seeing that in the transcript, whether we actually turned over the copy or not. But again, our standpoint is that report is unnecessary due to the officer's testimony under Evidence Rule 602, and then the defendant's own knowledge of the operability of the firearm.
How many continuances should a trial court give? I mean, we see a pattern here, and look, I understand things happen, right? But this trial is going on in progress and it just keeps getting continued. At what point is it unreasonable for the trial court to keep continuing the case?
And I think that's ultimately what Attorney Gieseke is asking you guys to decide here. The evidence rules, the case law does not give a limit. It goes to the least severe sanctions consistent with the purpose of discovery. I believe if this were willful violations, obviously our position is these were not willful. This was not the greatest discovery job in the world, but I don't believe any part of this on our office was willful. So I think you could start going these higher sanctions if there are people like actually withholding evidence, not putting it on there, trying to play the actual surprise game, not the kind of...
At what point does negligence become willful? I mean, are we supposed to look at somebody's performance over and over again, like forgetting to turn something over or just simply not turning it over? And if it was negligent, at what point do we look at this happening several times and determine, okay, that goes beyond just negligent, it's willful?
I think that goes again to the totality of the discovery responses. If this were a case where like, nothing had been turned over on the day of trial, and the judge continued it, we again turned over nothing, obviously that would look much worse for us in our position. In this case, there were only singular pieces of evidence. The first one was witness disclosure, then the firearm report, which we never turned over until the second one. Then it was continued only for that the second time, and the judge made very clear at that second continuance he was going to up the sanctions if it was not complied with at that time. He said, if you turn over everything you have now, at this point, if you don't turn something over and it pops up on the next trial date, it's not coming in. And that is the next rung on the ladder of sanctions, and I think that's where the judge was going. Fortunately for us, we didn't reach that rung. We were able to complete the trial at the next setting.
So in this case, there were 2 continuances that were related to discovery issues. How do we put that into the calculus of abuse of discretion?
So again, you have to look at the standard is that unreasonable, arbitrary, or unconscionable. The case law has given courts a very wide array of discretion when determining these discovery sanctions. They're the ones that are there. They're the ones that are dealing with the parties. And so when you're looking at this, I think a lot of deference has to go to that trial court decision. Why are they making these decisions? And I think we have an abundance of a record here, some of the in-chambers conversations, other issues that went on as far as the discovery was ongoing. So I think that abuse of discretion for these kind of cases is going to be a high bar. You actually have to look at it and determine that the judge, was unconscionable in giving the state a continuance to disclose a witness. And just going to moving on to the second assignment of error, unless there's any questions left for the first one.
You still have 5 minutes.
Okay.
Okay?
Probably not going to take that long, but just going to touch on it a little bit. So this goes to the sufficiency and the manifest weight. Obviously, sufficiency, if you believe the evidence, can this evidence sustain a verdict of guilt? And the manifest weight, did the trier of fact clearly lose its way and create such a miscarriage of justice that the conviction must be reversed and a new trial ordered? Quite frankly, I do not believe that is the case here. We have the officers responding to the scene based on a shot spotter, which the court equated to an anonymous tip, the LTI 2020. Officer Mitch was able to testify to their response and how that kind of works with their systems. When they arrive on scene, they hear a gunshot. They start looking around. They encounter Mr. Maynard, who makes several admissions to the officers about firing the gun, as well as imbibing in alcohol. The officers find the gun. They find spent shell casings. They find rounds in the weapon itself. And then while Officer Meese is talking to Mr. Maynard, he admits to drinking. There are observations of glassy, watery eyes. There's a slow reaction time. Mr. Maynard is exhibiting slurred speech. And Officer Meese, I believe, also testified to a mild to moderate odor of alcoholic beverage coming from Mr. Maynard's
So
breath.
what if there was no testimony of the officer of operability and there was no report? Based on the facts of the case, is there enough for operability?
I think that we would have enough for operability based on the spent shell casings matching the weapon that was found at the scene. I think it was a 22 Kel-Tec, as well as Mr. Maynard admitting to the officers that he was firing the gun into the ground trying to clear a jam.
And how about shot spotter? Would that be part of the calculus or not?
I think it would be. That would be, as well as the officers hearing a gunshot on scene. The issue that we would run into there is how do we show that it was Mr. Maynard firing the weapon? I think the shot spotter is part of the calculus that gets us there, but what really would get us over that beyond a reasonable doubt hump is the spent shell casings on a weapon that he admits is his and his admission to firing it into the ground.
And what about with regard to the using weapons while intoxicated? What's the evidence in the record to support that?
That goes back to his admission to drinking. And again, our attorney Gieske mentioned the impairment versus consumption argument. The admission admittedly goes towards consumption. But for the impairment aspect, and again, these are officers, they may not have done field sobriety tests, but they interact with intoxicated people, I don't want to say all the time, but probably relatively frequently. And they have certain indicators, as well as lay people that can have indicators if they testify to someone who is intoxicated. Those are things like we have here: glassy, watery eyes, a slow reaction time, slurred speech, and then Officer Meese specifically, who, while Officers Contras and I believe Scheidler were doing the investigation, was the one interacting with Mr. Maynard, noted the mild to moderate odor of alcoholic beverage coming from his breath.
And did Officer Meese testify as to his background and training with regard to intoxication?
I don't recall specifically if he did or not.
Did any of the officers testify as to such?
I believe they were asked if they could identify an intoxicated person. I don't know if they went into their, like, the 40-hour alcohol class they do or anything like that. I know on cross-examination, defense counsel, I believe, brought up, you're trained to do these certain things. Did you do these certain tests? So I know that was part of cross-examination. I'm not sure if that was part of our direct.
Was the qualifications challenged
It's part of the,
as with regard to being able to testify on intoxication?
you mean like in the trial court?
Right. Did the defense challenge the qualifications of the officers?
I don't believe they did. That was more of a cross-examination credibility issue. You don't have these certain tests. If there are no further questions,
Thank you.
thank you, judges.
You have your 3 minutes reserved.
Okay, thank you. So, I just wanted to emphasize that the focus of the first assignment of error is really the constitutionality and the procedural aspect. So really, the remaining evidence does not inform the analysis if you excise. That's really the harmless error, second assignment of error. And to counsel's point that the defense would have been well aware the gun was operable, I think to the contrary, if I posit the question, if a semi-automatic gun has a broken extractor, can it fire a round inserted in the chamber? Who knows? I don't know that. That sounds like expert testimony to me. So,
Ms. Gieske, with the shell casings,
yes.
how did that testimony come in about the shell casings matching his weapon?
I think that would have been, and I did not re-review, tried to skim it while counsel was speaking, but I think that when they spoke about collecting them from the yard, and then I think it's the NIBIN report speaks about matching up rounds with particular weapons.
So that wasn't discovery that
That's
was in the
objected to.
evidence bag?
I don't believe so. I believe
that was turned over.
I think that was turned over.
Okay.
Yes. I believe so.
Okay, thank you.
As far as I wanted to emphasize that the Pittman case was distinguishable. So in Pittman, no evidence was disclosed in discovery. So that rationale was that if you see nothing coming across, you can maybe think there's a hiccup in the discovery disclosures and maybe file a motion to compel to see what's going on there. Here we did have a single discovery response that made at least one disclosure of a witness. So counsel,
So
labored.
basically, you had every reason to believe that the
That
state
was
had
it.
disclosed what they had to disclose.
That's exactly where I was going, Your Honor, that was going to be it.
And there's something about this wording, and I'm paraphrasing, I don't recall the specific wording, but
Sure.
it said something like, well, we'll give it to you when it's available.
As it becomes, something like, and I wrote that down, hold on.
Like, to be
It was
provided when
anticipatory, would be
available.
provided as soon as is made available.
As soon as is made available.
Right.
There's a way of reading that implies that it does not yet exist.
Right. It
And-
doesn't exist and maybe will never exist. That when it's made available, we'll give it to you. And since it wasn't turned over, counsel understandably thought, okay, it's not there. So regarding the formal copy, the record seems to support that the testify report may have been shown when it was prompted in court and when the evidence bag was open. I think there was some inspection there, but when I went through the list of exhibits, it's not an exhibit. So it was never actually, I don't think a formal copy was disclosed, or at least it wasn't made an exhibit. And then as far as the number of continuances, so this is where I think that, I think it stands to reason that in-progress continuances should be scrutinized a bit more harshly than pretrial. There's going to be, yes, speedy trial issues with
Is
pretrial.
there any case law that you can point to that effect? I understand the argument.
Not, I didn't research that angle, so I don't know. It's just really a common sense practitioners once you're in trial, everybody's there, the clock is ticking, the witnesses are all there. You know, the expediency takes on a more strenuous, you know, impact once trial is happening. So I think that the fact that there were two here, two different bites at the apple, in addition to the 3 pretrial continuances, sort of informs the overall calculus.
Well, counsel, at that point, you've already committed to a particular defense, right?
Yes, that is true, yes.
And
so shifting, go ahead.
Is that preserved in the final trial in terms of the prejudice that counsel's committed to a particular defense and can't shift course?
I think that, if I'm understanding your question correctly, that does inform the prejudice analysis because you know, it's up until trial starts, things can be adjusted. And, you know, like I said, maybe entailing getting different experts, shifting the theory of the fact, all that can happen pre-trial, that once you're locked in, it becomes difficult, if not impossible, to shift gears.
Well, and at that point, when Officer Contras, if I'm remembering his name right, at that point when he had testified, other witnesses, at least Lieutenant Mitch, had already come and gone, had already testified and been cross-examined, and so there was certain evidence that was already completed in the case and could not be gone back over at that point.
Yes, that is true.
And
Yes,
so that
and-
does demonstrate at least some degree of prejudice in terms of the defense being committed to a particular path.
It does, especially where Lieutenant Mitch's testimony was limited. So but she still then kind of snuck in the fact that shot spotter details latitude and longitude. So it does inform the operability, which defense counsel was again laboring under the impression that that was not going to be able to be proved. So Mitch's testimony had already come and gone, which in at least a tangential way informed that, gave some circumstantial possibly evidence that had already, yes, come and gone. And quickly, as far as the abuse of discretion, typically counsel's right. Typically wide latitude, we all know the law on that, but we don't have to shoot in the dark here. Darmond and really Parson is the first case. Gives you 3 factors to look at to see whether the trial court abuses discretion. So you don't need to resort to generic, arbitrary, capricious. You can look to those 3 Darmond factors and look through that lens to see whether the trial court abused discretion and how it answered these discovery violations. And as far as the second assignment of error, the circumstantial evidence of operation, I would argue that no, actually the evidence is kind of a little bit all over the map, that it really comes down to that highly technical, because operability, if you look at 292311B1, it says a firearm is something that can expel a projectile or something that is inoperable but can be readily rendered operable. That is the crux of this case. Could this gun? We don't know. And that's really what we're asking for is, at a minimum, give a shot at a new trial to actually have the experts discuss that, because that's an important issue in this case and probably future gun cases, is does that meet the operability standard? We don't have enough to know, enough information. And as far as the impairment, we do have, like I said, some evidence of consumption, but his admission, it was 1 to 2 beers and he didn't finish the second. That's not much. And I can't emphasize enough, the watching the body cam and the MVR cams, he does not appear like he's falling off his rocker. You know, he's not stumbling, he's not slurring, he's, you know, saying he was stupid, but he's not, can you take these rings off, you know, my hands are hurting. He gives his personal information. Like, he doesn't fall asleep on the way. He's not belligerent. Like, it's not really as clear-cut as it might seem when you actually use your own, you know, scrutiny and watch the videos.
Counsel, one follow-up question for you. After that second continuance, when the report was discovered in the evidence bag,
Yes.
was a copy of the report actually turned over to the defense?
Not that I can see from the record, no. If there are no further questions, we would just ask if this court reverse and remand or discharge. Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. We wish you both a wonderful afternoon. Thank you.